They had him pinned against the hood of an unmarked police cruiser in the parking lot of a Cincinnati, Ohio strip mall on a Tuesday afternoon in November. His cheek pressed against the cold metal, his arms wrenched behind his back, while three plainclothes officers from the Cincinnati Police Department's 3rd District worked with the practiced efficiency of men who had done this many times before and expected, as they always had, that there would be no meaningful consequence for doing it again. The brown cardboard package he had been carrying, picked up 12 minutes earlier from a FedEx office on Reading Road, had been thrown to the asphalt when they grabbed him, and it had split open on one corner, and a detective named Lieutenant Brian Kowalski was crouched over it with a folding knife, cutting through the packing tape with the unhurried confidence of a man who was certain he was about to find something that would justify everything he was doing and everything he had done. The man on the hood said nothing. He did not struggle. He did not plead. He turned his head so he could see what Kowalski was doing to the package, and he watched with an expression that the other two officers, Sergeant Dale Pruitt and Detective Marcus Webb, no relation to the man he actually was, would spend a very long time afterward trying to describe accurately, because it wasn't fear, and it wasn't confusion, and it wasn't the anger they were used to seeing in this position. It was something they didn't have a word for yet, something that would only acquire a name for them later, when they finally understood what they had done and who they had done it to. What was on his face was the expression of a man who has been waiting, with absolute certainty, for a door to open, and has just heard the handle turn. The strip mall on Reading Road in Roselawn sat between a hair supply store and a tax preparation office in the kind of commercial block that defines the working bones of a Cincinnati neighborhood. Not glamorous, not depressed, just functional and continuous. The kind of place where people cash checks and buy groceries and pick up packages and move through their Tuesday afternoons without expecting anything remarkable to happen. The parking lot held maybe 30 cars on a good day, and today it held 22, and the three officers in the unmarked Dodge Charger had been in that lot for 58 minutes before their target walked out of the FedEx office with the brown package under his arm. They had been watching him for 19 days. They had been watching him because he had been asking questions that made certain people in the 3rd District uncomfortable, questions about patrol patterns, about use of force incident reports, about the specific geography of traffic stops conducted in Roselawn and Bond Hill and Avondale over the past 4 years. They had been watching him because someone in the precinct had flagged his name after he submitted a public records request through the Hamilton County Clerk's office, and the flag had traveled up through 2 supervisors until it reached Kowalski, and Kowalski had decided, with the casual arrogance of a man who had operated without accountability for long enough to mistake impunity for invincibility, that the best way to handle a person who was asking uncomfortable questions was to make his life uncomfortable enough that he stopped asking them. What Kowalski did not know, what none of the 3 men in that Charger knew, what the captain who had quietly authorized the surveillance did not know, what the entire 3rd District had somehow collectively failed to discover in 19 days of watching this man, was who he actually was and what he had actually been doing in Cincinnati for the past 16 months. His name, the name that appeared on his apartment lease and his Ohio driver's license, and the library card he used at the Cincinnati Public Library branch on Vine Street, was Marcus James. He was 44 years old, 6 feet 2 inches tall, with deep brown skin, a close-cropped fade with a slight widow's peak, sharp observant eyes behind wire-rimmed glasses, and the kind of quietly commanding physical presence that comes not from size or aggression, but from the particular quality of attention he brought to every environment he entered. The attention of someone who is always, simultaneously, the most observant person in any room and also the person least likely to make you aware of that fact. He was wearing dark charcoal trousers, a navy blue knit sweater, a charcoal wool overcoat, and brown leather Oxford shoes, and the package he had been carrying contained, according to its shipping label, a set of replacement ink cartridges for a Brother laser printer. The FedEx tracking number was real. The ink cartridges were real. The package was exactly what it said it was. But the man carrying it was not exactly who his Ohio driver's license said he was, and the work he had been doing for 16 months in Cincinnati, Ohio, was not the freelance urban planning consulting work that his carefully constructed cover identity described, and the records request he had submitted through the Hamilton County Clerk's office was not the act of a curious private citizen. It was one of 47 documented investigative steps in a federal investigation that had been authorized at the Deputy Assistant Attorney General level, reviewed by a federal judge, and supported by a case file that now ran to over 300 pages and documented with the kind of evidentiary precision that federal prosecutors dream about and defense attorneys dread. One of the most systematic and long-running patterns of racially targeted law enforcement misconduct in the state of Ohio. Lieutenant Brian Kowalski cut through the last layer of packing tape and opened the box and found ink cartridges. 4 black, 2 cyan, 2 magenta, 2 yellow, all in their original Brother manufacturer's packaging. None of them contraband, none of them illegal, none of them anything other than exactly what the shipping label said they were. He stared at the contents of the box for a moment that stretched considerably longer than its actual duration, and then he stood up and looked at the man spread across the hood of the cruiser, and the man turned his head from the cold metal and looked back at him through the wire-rimmed glasses that had somehow stayed on his face through the takedown, and Kowalski opened his mouth to say something, though what exactly he was going to say was unclear even to him, when one of the other officers, Sergeant Pruitt, reached into the man's coat pocket and produced a slim black billfold, and opened it, and looked at what was inside, and said Kowalski's name in a tone of voice that Kowalski had never heard Pruitt use in 11 years of working together, a tone that had no category in the professional vocabulary of law enforcement, because it was the tone of a man who has just looked down and realized the ground he thought was solid is not there. Kowalski took the billfold. He read the identification card inside it twice because the first reading didn't fully process. Then he read it a third time, and then the parking lot of the Reading Road Strip Mall in Cincinnati, Ohio became the most expensive piece of asphalt in Hamilton County history. The identification card identified the man as Special Agent in Charge Darius Elias Monroe, Federal Bureau of Investigation, Civil Rights and Public Corruption Task Force, Department of Justice. It bore the FBI seal, a federal badge number, a security clearance indicator, and an emergency verification line. Kowalski held the card in his hand and felt, in a physical and not merely metaphorical way, the specific sensation of a floor disappearing. Behind him, the 2 officers who had conducted the takedown had gone very still. The man on the hood of the cruiser, Special Agent in Charge Darius Monroe, turned his head back toward the sky and closed his eyes for exactly 3 seconds, and then he opened them, and then he said, in a voice that was completely level and completely clear, and somehow more authoritative for having come from a man still pressed against the hood of a cruiser, that he needed them to remove the restraints from his wrists, that he needed his property returned to him, and that they should be aware that everything that had occurred in this parking lot in the last 4 minutes had been recorded by 2 separate monitoring systems that his task force had deployed as standard field protocol, that this incident would be reported to the DOJ Office of Professional Responsibility within the hour, and that they should contact their union representatives and personal attorneys as soon as possible. He did not raise his voice. He did not need to. The restraints came off. The package was returned, and Darius Monroe stood up from the hood of the cruiser, straightened his wool overcoat, picked up his package from the asphalt, and walked to his car with the measured, unhurried stride of a man for whom this afternoon had gone, if anything, slightly better than expected. To understand who Darius Monroe was, and why what happened in that Cincinnati parking lot represented not just a personal humiliation, but the unraveling of something that had been building for a very long time. You have to go back much further than 16 months, much further than the FBI, much further than the Department of Justice and the task force and the federal case file running to over 300 pages. You have to go back 30 years to a neighborhood in Cincinnati's West End called English Woods, where a 14-year-old boy was sitting on the front steps of a brick apartment building on a September evening, watching two Cincinnati police officers question his older brother, who was 22, and had just gotten off his shift at the UPS warehouse on Coleraine Avenue, about a car break-in that had occurred 3 blocks away while his brother was documentably at work. The officers were not asking questions so much as conducting a performance of authority, of presumption, of the particular kind of certainty that has nothing to do with evidence and everything to do with the decision, already made before they pulled up, that the young black man they were looking at was the right answer to the question they were asking. His brother had his pay stub in his pocket. He showed it to them. One of the officers had looked at it and handed it back without comment, and then asked his brother where he had been between the hours of 7 and 9, which were hours during which his brother had been at a warehouse on the other side of the city with 47 coworkers. His brother answered every question. The officers left 40 minutes later without an apology. The boy on the steps had watched all of it and had not said a single word, not because he had nothing to say, but because he was already doing something more useful than talking. He was memorizing the badge numbers, the cruiser number, the time, the questions, the pay stub, the 40 minutes, the absence of an apology. He was 14 years old and he was already building a case, because something in him understood, with a precocious and entirely intuitive clarity, that the only language these particular interactions would ever fully respond to was the language of documented, verified, legally actionable fact. His full name was Darius Elias Monroe, and he was the second son of a woman named Catherine Monroe, who worked as a registered nurse at Cincinnati Children's Hospital, and a man named Robert Monroe, who drove a city bus for the Cincinnati Metro, and who had, in 31 years of driving the same routes through the same neighborhoods, developed the kind of unillusion understanding of his city that comes from seeing all of its parts from the same seat every day. They lived in English Woods in the apartment building on the corner, and they were not a family with connections or resources beyond what Catherine's nursing salary and Robert's Metro pay provided. But they were a family with a specific and non-negotiable set of values about education, about conduct, about what it meant to be a person of quality in a world that would sometimes make quality very difficult. And those values had been transmitted to Darius and his brother Marcus with the particular effectiveness of parents who don't just say what they believe but live it visibly, every day, in a way that their children can see and measure themselves against. Darius had watched his father handle every difficult passenger, every hostile exchange, every frustrating bureaucratic obstacle of his career, with a calm, deliberate professionalism that never confused dignity with passivity, and he had carried that model forward into everything he subsequently did. He had graduated from Western Hills High School with a 4 GPA, a track record as captain of the debate team, and an acceptance to Ohio State University in Columbus on a full academic scholarship that covered tuition, housing, and a small living stipend. At Ohio State, he had majored in criminology and political science simultaneously, driven by the conviction that the legal and political systems were so thoroughly intertwined that understanding one without the other was like trying to read a book with half the pages removed. He had graduated summa cum laude, delivered a senior address at commencement that his criminology professor told him afterward was the most coherent student analysis of structural law enforcement bias he had heard in 30 years of teaching, and been accepted to the University of Michigan Law School in Ann Arbor, where he had spent 3 years developing the legal vocabulary that gave precise and prosecutable form to everything he had been thinking about since he was 14 years old on the steps of his building in English Woods. He had graduated from Michigan law with honors, received offers from 4 private firms and 2 federal agencies, and had chosen the FBI because the FBI had the jurisdictional reach, the investigative authority, and the institutional mandate to do the specific kind of work he had been pointing himself toward since September of his 14th year, which was the work of walking into the places where power had made itself comfortable with abuse, and making that comfort cost something real. He had spent his first 6 years at the FBI as a field agent in the Cincinnati field office, working organized crime and public corruption cases. And in those 6 years, he had developed a reputation for evidentiary thoroughness that bordered on the legendary. Cases he built did not fall apart on appeal, because he constructed them with the kind of redundant, interlocking documentation that left no structural weakness for a defense attorney to find and exploit. He had been promoted to supervisory special agent at 34, transferred to the DOJ's Civil Rights and Public Corruption Task Force at 37, and had been named special agent in charge of a 3-state operational territory at 40. One of the youngest people to hold that designation in the task force's history. In the 4 years since his appointment, he had overseen investigations that had resulted in federal charges against a county sheriff in rural Kentucky, 2 city council members in a Columbus suburb who had been steering municipal contracts to businesses they held undisclosed interests in, and a police lieutenant in Dayton who had been running an evidence room theft operation for 6 years. Each investigation had been built the same way, methodically, patiently, from the ground up, with Darius Monroe spending whatever time was necessary in whatever environment was necessary to assemble evidence that could survive the most aggressive possible federal prosecution and still come out whole on the other side. The Cincinnati investigation had begun 22 months before the parking lot incident, when a civil rights attorney named Vanessa Cole, who ran a small practice on Reading Road in Roselawn, and whose clients were disproportionately residents of the neighborhood served by the 3rd District, had submitted a formal complaint to the DOJ's Civil Rights Division, documenting what she characterized as a pattern of racially targeted enforcement in the 3rd District that had been ongoing for at minimum 5 years. The complaint was 49 pages long and included testimony from 23 clients, statistical analysis of publicly available traffic stop data showing that black drivers in 3rd District patrol zones were stopped at a rate 3 times higher than white drivers despite representing a smaller proportion of the driving population, documentation of 11 specific incidents in which clients had been stopped, searched, and in several cases arrested on charges that had subsequently been dismissed for lack of probable cause, and a detailed account of what 3 separate clients had independently described as being approached by 3rd District officers and asked for cash payments in exchange for having charges reduced or dropped. A pattern that, if Vanessa Cole's clients were describing it accurately, constituted federal extortion under the Hobbs Act and civil rights violations under color of law that carried mandatory minimum federal sentences. The complaint had been received by the DOJ's Civil Rights Division, reviewed by a senior attorney named Patricia Holloway, escalated to the task force, and placed in front of Darius Monroe on a Thursday morning in January of the year that preceded the parking lot incident. He had read every page. He had asked Patricia 3 questions. He had told her he needed 6 weeks to build a cover identity and 6 months to make meaningful inroads into the community. She had told him to take whatever he needed. He had said 6 weeks was enough. It had taken him 4. As Marcus James, freelance urban planning consultant, Darius Monroe had rented a 2-bedroom apartment on Burnett Avenue in Avondale, close enough to the Roselawn and Bond Hill neighborhoods that were the 3rd District's primary patrol areas to be useful, far enough from any address associated with his real identity to be safe. He had set up a genuine-looking consulting practice with a website, business cards, a LinkedIn profile with a carefully constructed professional history, and an actual portfolio of publicly available urban planning documents from other cities that he could reference credibly in conversation. He had attended community board meetings in Roselawn and Avondale. He had become a regular at 2 neighborhood coffee shops and a barbershop on Reading Road where, over the course of many months, he had developed relationships with people who had stories, specific, detailed, consistent stories about the 3rd District that corroborated and extended, and in several cases, dramatically exceeded the scope of what Vanessa Cole's complaint had described. He had met Earl Davidson, who owned a small auto repair shop on Seymour Avenue, and who had been paying what amounted to a monthly tribute to 2 3rd District officers for 2.5 years, to avoid having his customers and employees subjected to constant pretextual stops. He had met a woman named Denise Porter, who ran a hair salon on Reading Road, and who had been cited for fictitious code violations that disappeared whenever she made a cash payment to an officer whose name she knew, but whose badge number she had never been able to confirm. He had met a pastor named Reverend Thomas Webb at Morning Star Baptist Church on Rockdale Avenue, whose congregants had brought him enough documented stop-and-harass incidents that he had begun keeping a log, a handwritten composition notebook with dates, times, badge numbers where known, and descriptions of each incident, that he showed Darius over coffee in the church fellowship hall one Tuesday morning, and that Darius spent the subsequent 40 minutes reading, with the focused attention of a man, encountering the exact thing he had been looking for. Over 16 months, Darius Monroe had assembled a case file that was, in the assessment of the DOJ attorneys who reviewed it, among the most comprehensively documented civil rights and public corruption investigations they had processed in a decade. It contained direct testimony from 31 witnesses, all of whom had been interviewed multiple times, all of whose accounts had been cross-referenced and corroborated against each other and against documentary evidence. It contained financial records obtained through grand jury subpoenas that showed unexplained cash deposits in the personal bank accounts of 4 3rd District officers, including Kowalski, that were inconsistent with their recorded salaries and had no legitimate documented source. It contained body camera footage, obtained through FOIA requests that had been submitted not by Darius himself, but by a DOJ civil attorney operating through a front organization specifically established for the purpose, showing 11 specific stops in which the officers' stated justifications for the stop were directly contradicted by the visible evidence on the footage. It contained the Reverend's handwritten composition notebook, which had been photographed page by page and entered into the federal evidence management system with Reverend Webb's full cooperation and written consent. And it contained the records of 3 controlled interactions that Darius had personally conducted, with full DOJ authorization and federal court supervision, in which he had been approached by 3rd District officers in the context of his cover identity as a business owner in the corridor, and had been explicitly solicited for cash payments, each of which had been recorded by a device that was as legal as it was invisible, and that had captured audio of sufficient clarity and specificity to make a federal prosecutor smile in the way that federal prosecutors rarely allow themselves to smile in professional settings. The grand jury had been impaneled 8 weeks before the parking lot incident. The indictment had been drafted. The charges had been reviewed by the DOJ's Office of the Deputy Attorney General. The unsealing date had been set. Everything was in place, every piece of evidence secured, every witness protected, every legal mechanism engaged and ready to operate. The parking lot incident had not disrupted any of this. It had not been able to disrupt it because the case was not located in Darius Monroe's person or his package of ink cartridges, but in a secure federal system that Kowalski and Prute and DeLuca and everyone above them in the 3rd District had no access to and no awareness of. What the parking lot incident had done, operationally speaking, was add itself to the case, become itself a piece of evidence, itself a documented act of misconduct, itself a federal charge, and trigger the acceleration of the unsealing timeline from the following Friday to the following Monday. Because Sandra Kim, the DOJ task force attorney who received Darius's field report within 90 minutes of the incident, had looked at the documented facts of what had happened and decided, after a 20-minute phone call with Patricia Holloway, that there was no legitimate reason to wait 5 additional days and several very good reasons not to. The indictment was unsealed on a Monday morning at 9 o'clock in the lobby of the Potter Stewart United States Courthouse on 5th Street in downtown Cincinnati. It named 13 defendants: Lieutenant Brian Kowalski, Sergeant Dale Pruitt, Detective Marcus Webb, who had been present at the parking lot, and 10 additional 3rd District officers, on charges that included 47 counts of civil rights violations under color of law, 18 counts of extortion under the Hobbs Act, 12 counts of wire fraud, 9 counts of obstruction of justice, and 3 counts of interference with a federal investigation. The last category being the charges that arose directly from the parking lot incident, and that were, in the legal opinion of the defense attorneys who reviewed them the morning they were filed, the clearest and most easily provable charges in the entire indictment, given the existence of monitoring recordings and a federal agent's first-hand testimony. It also named 2 supervisory officers, a captain named Richard Holloway, no relation to the DOJ attorney, and a deputy commander named Frank Sessler, on charges of supervisory liability for creating the conditions under which the misconduct had operated for 5 years, without internal accountability. The press conference at which United States Attorney for the Southern District of Ohio, Jennifer Walsh, announced the indictment ran 43 minutes and was attended by reporters from every major Ohio newspaper, the Associated Press, the Washington Post, and 2 television network affiliates, and the clip of Walsh describing the scope and duration of the misconduct was played on the national evening news that night and shared 300,000 times on social media by the following morning. Vanessa Cole, the civil rights attorney whose 49-page complaint had started everything 22 months earlier, was not at the press conference. She learned about the indictment from a text message sent by a paralegal who had been watching the live stream, and she read the names in the indictment on her phone in the parking lot of a grocery store on Reading Road because she had been on her way to buy lunch when the notification came through, and she sat in her car for a while after reading it, not because she was surprised. She had known for months that a federal investigation was in progress, though she had not known its full scope. But because there is a specific kind of feeling that comes from spending 2 years telling people that something is happening, that the pattern is real, that the documentation exists, that the law has words for this and those words have consequences attached to them, and then arriving at the moment when the consequences are actually measurably real and not just a thing you believe in and advocate for and build your professional life around. She sat in the grocery store parking lot for 11 minutes and then she called her most senior client, Earl Davidson, from the auto repair shop on Seymour Avenue, and she told him. He was quiet for a moment, and then he said that he needed a minute, and she said she understood, and they both stayed on the line without talking for a while, because sometimes the adequate response to justice arriving is not words, but the simple shared acknowledgement that it has arrived. The trial ran for 9 weeks in federal court in Cincinnati. Darius Monroe testified for 3 full days, presenting the evidence assembled across 16 months in the methodical, precise, unshakable manner that had become the defining characteristic of his professional testimony over a career that now included federal prosecutions in 4 states. He was cross-examined by 4 different defense attorneys over 2 days, each of whom approached the task with varying strategies, one attempting to challenge the reliability of the witness testimony he had gathered, one attempting to suggest that the controlled interactions had been entrapment, one attempting to question the chain of custody of the financial records, and one, the attorney representing Kowalski, attempting the most aggressive approach of all, which was to suggest that the parking lot incident had been in some way provoked by Darius's own conduct during the investigation. Darius had answered every question with the same quality of attention he brought to every professional task: complete, specific, documented, and entirely unintimidated. And the cross-examination of an experienced federal agent who has 16 months of meticulous documentation behind him and knows that every claim he makes is supported by physical evidence that is sitting in a federal archive, waiting to be retrieved, had the quality, as one of the trial observers later wrote, of watching someone attempt to dismantle a building with a toothpick. The jury deliberated for 4 days. 11 of 13 defendants were convicted. The 2 acquittals were junior officers on the most peripheral charges, officers whose involvement the evidence had documented but whose individual culpability the jury found insufficiently direct. Everyone else was convicted. Kowalski was convicted on 22 counts and sentenced to 12 years in federal prison. Captain Holloway and Deputy Commander Sessler received 7 and 8 years respectively. The remaining convicted defendants received sentences ranging from 3 to 9 years, depending on the specificity and duration of their individual involvement. The Cincinnati Police Department entered into a consent decree with the Department of Justice that was, in its scope and specificity, among the most comprehensive such agreements reached with a major city police department in recent years. It required the complete restructuring of the 3rd District's supervision and accountability protocols, the mandatory installation of body cameras with 24-hour retention requirements, and independent oversight of footage access, the creation of an independent civilian review board with genuine investigative authority and subpoena power, comprehensive revision of the department's use of force and traffic stop policies, a 5-year federal monitoring period with quarterly public reporting, and the appointment of an independent monitor, a former federal judge from Cleveland, with authority to recommend sanctions for noncompliance. The city of Cincinnati settled the parallel civil lawsuit brought by Vanessa Cole on behalf of her clients for $38 million, distributed among the 31 documented victims of the misconduct scheme, according to a formula negotiated by Cole and approved by the federal court. Earl Davidson's share, combined with the satisfaction of 3 years of extortion payments being legally recognized as what they were, allowed him to pay off the commercial mortgage on his Seymour Avenue repair shop. Denise Porter used her settlement to renovate her salon and hire 2 additional stylists. Reverend Webb donated his portion to the Morning Star Baptist Church Building Fund, specifying that it be used for the expansion of the church's youth services program, because he believed, as he told the church newsletter in a statement about the donation, that the best response to years of a community being targeted was to invest in that community's youngest members, who deserved to grow up in a neighborhood where the people with badges who drove through it were protecting them and not preying on them. Darius Monroe returned to his real apartment in Columbus, Ohio 3 weeks after the sentencing, driving the same charcoal Honda Accord that had sat in the Avondale apartment complex parking lot for 16 months under the name Marcus James. He had already filed the paperwork to formally close the Marcus James cover identity and had submitted his operational debrief report to Patricia Holloway, who had read it and sent him a 3-sentence email that said, in its entirety, "The documentation on this one is going to be a training standard for years. Take the time you've earned, and when you're ready, call me, because we have a situation in Louisville that has your name on it." He had read the email, closed his laptop, and sat in the quiet of his apartment for a while, not thinking about Louisville or the next file or the next cover identity, but thinking about English woods and a September evening 30 years ago, and a 14-year-old boy memorizing badge numbers on a front stoop, while his brother showed a pay stub that should never have needed to be shown to officers who should never have needed to be there. He thought about what it meant that the 14-year-old boy had grown into a man whose specific professional function was to be there. When the law was being used as a weapon against the people, it was supposed to protect, and to be there not as a victim of it and not as a bystander to it, but as the person who built the case that ended it. He thought about his mother and his father and the specific and non-negotiable values they had given him. He thought about 30 years of work and whether it had amounted to something. He thought about Earl Davidson paying off the mortgage on his shop, and Denise Porter hiring 2 new stylists, and Reverend Webb's composition notebook full of handwritten dates and times and badge numbers, and the kids who would grow up in that neighborhood in a Cincinnati that was not entirely fixed, but was measurably, documentably, consequentially more accountable than the Cincinnati that had existed 16 months ago. Because one specific and deliberate injustice had been named and documented and prosecuted and answered. And sitting in the quiet of his apartment, Darius Monroe decided that yes, it had amounted to something. It had amounted in the specific and countable and permanent way that only documented, proven, sentenced justice can amount to something, to enough. Enough for today. Enough to rest on for exactly as long as he needed to rest on it, which he had already calculated was approximately 2 weeks. And then he would call Patricia Holloway back, and there would be a file on a table in Washington with Louisville at the top of it, and he would pick it up, and he would read it, and the work would continue, because the work was always the answer, and he had known that since he was 14 years old, and it had never once given him a reason to stop believing it.